They seem they can't stop gun violence, but they want to pull you over for marijuana smells. Illinois Supreme Court to determine if cannabis odor is cause for vehicle search. Illinois Supreme Court heard arguments Wednesday as to whether the smell of cannabis alone is grounds for police officers to search a vehicle, marking a test of the state's 2020 recreational marijuana legalization law. The court heard two consolidated cases of individuals who were in vehicles that were searched after an officer used the smell of cannabis as probable cause. And People v. Redmond, defendant Ryan Redmond was pulled over by Illinois state police officers for an unsecured license plate, seems fishy, and driving 3 miles per hour over the speed limit. Court records show upon smelling cannabis, the officer searched the vehicle and found about 1 gram of cannabis in the center console. He later charged Redmond with misdemeanor of failure to transport cannabis in an odor-proof container, according to court documents. The other case, People v. Molina. The People v. Molina involved defendant Vincent Molina, who was a passenger in the vehicle when an Illinois state police officer smelled cannabis and searched the car, finding a small box of rolled joints. According to court records, Molina told the trooper he had a medical marijuana card prior to the search. The records state Molina was charged with unlawful possession of cannabis by a passenger in a motor vehicle for not storing the cannabis in an odor-proof container. Lawyers for Molina and Redmond argue the smell of cannabis alone should not be probable cause to search a vehicle, given that the substance is no longer illegal in Illinois. But Attorney General Kwame Raoul's I hope I butchered it. Office argued the law requires drivers to transport cannabis in an odor-proof container. Thus, the presence of cannabis odor is grounds for a search, even if the passenger is possessing an amount under the legal limit or has a medical marijuana card. It remains illegal to use cannabis in a vehicle and to transport cannabis in a vehicle in a container that is not odor-proof. November brief filed with Rawls read, thus, the odor of cannabis, whether in raw or burnt form, continues to provide police with probable cause to search. Mitchell Ness, Assistant Attorney General, continued to argue before the Supreme Court on Wednesday. Cannabis is no longer contraband in every circumstance, but that doesn't absolve the person from following the laws that are in place, he said. Chief Justice Mary Jane Theus said the central matter of the cases was roadway safety. The concern here is the safety of the public driving down the highway and impaired drivers. Diaz said at the oral arguments, we are concerned about drunk drivers and we're concerned about high drivers. Nationwide, the state-level chapter of American Civil Liberties Union and the National Association of Criminal Defense Lawyers filed a brief in support of Molina and Redmond, writing that allowing the odor of cannabis as cause of search for a vehicle will lead to biased enforcement against blacks and Latino Illinoisans. There are decades long pattern of police in this state using pretext like cannabis odor to disproportionately stop and search black and Latino drivers. The brief read, Illinois' stop and search policy unfairly subjects black and Latino drivers to at-will intrusions of their privacy and regulates them to second-class citizenry. The organization argued that the legalization of cannabis means its presence is not indicative of contraband or a crime. Alexandra Block, director of the ACLU of Illinois' Criminal Legal Systems and Policing Project and co-author of the brief, told Capital News, Illinois, a probable cause must be objective, not malleable. Even if the claim of smelling cannabis can be discretionary, honestly, it can be made up sometimes when officers are being less than honest because there is no way to challenge it. You can't see a smell or a body-worn camera, Block said. Because such accusations are unchallengeable in court, the results are often coming out worse for the drivers of color, she said. In People versus Molina, a trial court determined the odor of cannabis alone could not be cause for the search, since the odor of cannabis can be found on medical patients who grow their own marijuana plants or workers at cultivation centers and dispensaries. The ruling was reversed by appellate court before the case was consolidated with Redmond's and brought to the Illinois Supreme Court. Other top courts across the country have faced the same questions, most recently in Minnesota, where the state Supreme Court ruled the odor of cannabis and the absence of any other evidence is not enough, that the search would yield evidence of criminally, illegally, drug-related contraband or conduct. Last spring, the Wisconsin Supreme Court ruled the smell of marijuana is enough for police officers to search a vehicle. Most state Supreme Courts, like those in Delaware, New Jersey, Pennsylvania, and Vermont, have all determined the scent of cannabis is not enough for police to initiate a stop and search. The Maryland General Assembly passed a law last year prohibiting warrantless searches caused by the odor of cannabis. Last year, Senator Rachel Ventura D. Juliet introduced a bill that would amend the Illinois Vehicle Code and establish the odor of cannabis, raw or burnt alone, shall not constitute probable cause to search vehicles or persons. While the bill stalled last year, Ventura told Capital News Illinois in June she'd consider reviving the measure depending on how the court case is played out. The Supreme Court's decision is expected later this year. Everyone tell me what you think. I'm going to say, to my opinion, if something is legal, it's legal, right? It's legal. You can go into a store, any gas station, and purchase a pack of cigarettes. Cigarettes are known to kill Americans every single day. It causes lung cancer. It causes oral cancer. It causes skin cancer. Yet you can readily buy tobacco products as much as you want every single day and smoke it in your car with no issues. Now, I don't recommend you smoke in your car. So if the police sees and smells the smoke of marijuana, then that should be probable cause. But just by having marijuana on my person and then you smell it, I might have that strong Jason Beck strain. I might have that strong Rico strain. I might have a strain on me that's just too strong to be contained. Or I might have smoked marijuana 2 hours ago or an hour ago or maybe 5 minutes ago and got in a car as a passenger and has the scent of marijuana on me. So now because of the pure scent of marijuana, you get to violate my constitutional rights. I don't agree with what they're doing. I believe we need law enforcement, but we need good law enforcement and those who are not trying to just fish and then use this as a reason to pull someone over because they look the part, whether the color of the person is whatever they say it is, because there are white people who are harassed by officers too because of marijuana. This is a tool used pretty much on poor people all across the country and people who don't have the political power to be able to be heard in any way. It doesn't. We know that it definitely hurt and harms black and Latino people, but there are Asians who are dealing with it too. So to me personally, there needs to be something. Sorry. There needs to be something done about this. I think personally, if there is no smoke, there is no fire. So the pure scent alone of marijuana shouldn't be enough for a police officer to violate your rights. Tell me what you think in the comments, and please, my co-host, tell me what you think.
They're warrantless searches, guys.
Yeah, right.
This has been a battle we've been fighting from the jump, and it was low-hanging fruit. If a cop smelled weed, they had PC to crawl up your ass, whatever they wanted to do. And different states now are looking at this differently. I think that there's a twist here that, it's got to be in an odorless container, okay? Because if it's not, there's a technical violation, and it gives you they still want that to be probable cause to go do a full search. And
Dale,
I think it's horrendous, yeah.
Dale, would a vacuum seal bag be able to be defined as a smell-proof bag?
Well, they're not defining it, and that's part of the problem. And so odorless to one person is not odorless to another person, and they haven't set guidelines or standards. And let's be really, really clear about this case.
What if it's branded as a smelly-proof bag?
Well, it doesn't matter because it's up to the officer's discretion. One officer's smell is another officer's not smell. Let's be really clear about this case, though, for a second. This guy got pulled over because his license plate was wobbling. And then he got searched, and had
And wait, and he was 3 miles over the
Hold on, 3 miles,
and he
yeah.
was 3 miles over
Three
the
miles,
speed
which
limit.
is with 3 miles, which is in, you're going to take my lines here. 3 miles, which is in the margin of error, okay, in terms of trying to measure vehicle velocity. So he gets pulled over for the wobbly license plate, the plus or minus 3 miles, and then gets searched, and they find a gram. I'm just going to just say it because I talked about being angry last week. I do not believe this officer at all, okay? There is zero credibility. And I'm not universalizing that to all of our good brothers and sisters in law enforcement, but give me a break. 3 miles over with a wobbly license plate and you found a gram and you let this thing, you have the discretion about what you do and do not write up. And so you wrote this up. For a misdemeanor, for a smell-proof container that wasn't smell-proof enough, and now this thing goes all the way to the Supreme Court. This is the worst use of taxpayers' dollars in a million years. We have children being kidnapped. We have fentanyl. We have gun violence. We have real issues as a country to solve. And this is a terrible example of not seeing the forest through the trees. This gentleman who took this the distance and almost to Supreme Court deserves a Civilian Medal of Honor for pushing back against the biggest bureaucratic bullshit that we have covered today.
Freddie Flintstone policing, guys.
Man.
Freddie Flintstone Neanderthal policing. They have discretion. The judge has discretion. You go, you found a gram. No, I'm throwing the search out. But we need precedent from these courts, and we're just not going to get it. We're probably going to have the feds get in the middle of this, which they're not going to because it's illegal. And in the meantime, in California, we had this thrown out a long time ago because, you know, dogs had to be taken away because they smell weed and hit. No, you got to get them out of service. But there are places where still they just want to just fuck with you every chance they get. And when they decide they're going to do that, dude, this is what you end up with. A gram after all that.
So are you saying?
Stop it.
Are you saying, Dale, that this could possibly be a Judge Clarence Thomas come to the rescue case?
If he's not too busy accepting free travel from his billionaire boy, then he might be around to opine on this case.
Do we have a live,
Getting another sleeve cap right now,
CCTV
leave him
feed
alone.
to Clarence Thomas's bedroom right now?
We do have the live feed.
Please, pull up the
Adam,
feed.
Can you pull up the live feed to Clarence Thomas's? Yes.
Bedroom right now, please.
It's coming up. It's coming up.
The RV.
Yes.
RV TV.
Yep.
Make sure they respect Mr. Clarence Thomas, please. Put some respect on his name.
They telling you.
Just like he did with Anita Hill, we'll give him as much respect as he did with Anita Hill.
Hold
I got
on,
a
Yarrow.
Coke can
Yarrow,
for him.
here's for you. This is for you, Yarrow. This is for you, Yarrow, right here.
What do you
Here
have to say
go,
about this,
Yarrow.
Justice Thomas?
What you got to say about this, Yarrow?
I mean, I don't think RPG should have got the whole stomach, right? Biggest problem with RPG is she should have retired when she hadn't died so that somebody could replace her. She had zero succession policy.
Listen, he's mean mugging you. Yarrow, listen, he's looking at you right now. He's saying to you, what'd you say to me? What'd you say?
What I see
He's mean mugging you right now.
I see a
He's
micro
saying, what'd you
brief.
say?
I see a micro brief.
A micro brief.
There's a reason why it was cropped out there.
Oh man,
He's getting that sleeve tatted right now, bro.
Stop the cap. Stop the cap.
He said, did you know I was the Supreme Court judge?
Yeah, we're gonna roll. We're gonna roll. We got to keep it rolling.
Hold it up and pat it. Hold it up and pat it.
Yes, we got to keep this train rolling.